Yes, everyone, you're most welcome today. Okay, everyone, you're most welcome. I'm so obliged that we have you on the call. My name is Itaya Godfrey, Speaker, UC Law Society, main campus. And today I'm glad to inform you, as we've been reminding you, that we have the father of constitutional law. With us. This is our last eminent speaker series. And if you remember, we've been bringing different people, different distinguished guests to discuss and share with us about different matters, as you remember. But based on the fact that this is our last, we decided to try and engage Professor W.KANYEIHAMBA, and he agreed to be with us today on the call. Well, ladies and gentlemen, before we begin, I'd love to first invite the speaker, Kampala Campus, to lead us in a prayer. Madam Speaker, if you're on the call. Thank you. Madam Speaker, on the call? Okay, Madam Speaker is not on the call. Can I get, okay, so the President, main campus, Madam President, main campus.
No, please has not shared it.
Yes, kindly, please.
Yes, Mr. Lutaya.
Yes, kindly lead us in a prayer before we begin.
I am here.
Okay, thank you.
Is Iman back on the call or should I proceed?
You can proceed, Madam. Thank you.
Okay, let us pray. Lord Jesus, I thank you so much for this day that you have made. Thank you, Lord, because you are good and because you're awesome. I pray for this session that we are going to have, that, Lord, it shall be a success. I pray for strength. I pray for favor. I pray for all good things to happen. I pray for our speaker, Honorable Justice Professor George KANYEIHAMBA, that, Lord, you lead him to speak the things that you want him to speak to this generation. And I pray that this session shall be a fruitful one. I pray for the moderator, that everything shall go well. I pray for the members who are yet to join, that, Lord, they shall join in large numbers and that everyone shall learn something new today. In Jesus' name we have prayed. Amen.
Amen. Thank you so much, Madam President. Well, before we proceed, ladies and gentlemen, I would wish to give you a brief history, in as much as I know that we all know Professor George William KANYEIHAMBA. I would wish to take us back, Professor, University, and the students of law from other faculties or from other law schools that are joining us today. They would wish to know who is Professor KANYEIHAMBA.
Thank you very much, moderator. I am very honored and privileged to be talking through this medium to so many students and I believe members of staff about law on this eve of Uganda's independence after some 59 years since we got our freedom from the imperial power. I was listening to the media this morning, yes, and it's part of the problem we have of not listening properly. Uganda has never been a colony. Some governors may have treated it like a colony, but in law and international law, Uganda has never been a colony. It has been a protectorate. We were declared a protectorate of the British Empire in 1894. And since then, we have emerged from protectorate status to national status, never being a colony. I had yesterday people commenting on the eve of our, rather 2 days before our independence, including seasoned journalists, that we were a colony before, that during the colonial time, yeah, during the colonial time in the British Empire, but not in Uganda. Thanks to the traditional rulers of Uganda, when the British came to East Africa, they discovered a developed, well-ordered society, particularly in Buganda, in Ankole and the Toro and the Bunyoro kingdoms. And in their wisdom, they said, we cannot colonize these people because they are civilized, but we can protect them. So we were declared a protectorate, very much different from a colony. As I said, in some practical ways, we may have been treated by rulers as a colony, but they were wrong. We should have always been treated as a protectorate. So I wanted to make that correction. We have been independent for 59 years.
Yes, Professor. Yes, Professor.
Pardon?
Yes, Professor, you can go ahead.
Oh, yes, sorry, I thought you were correcting me. And during that period, we should have matured, adopted our own philosophy and destiny to determine our destiny, but we are still quarreling among ourselves. We have not had any principled, straightforward government or political party to guide us, so that we are very proud of our record and nation as other nations. At this ripe age of mine, with friends and some members of the family, people said, you have served this country well, and you have a legacy for which the younger generation should remember you. So what are you leaving us? I remember the words said by Professor Kennedy, the former president, young president of America, who excited the nation and us when we were young. And at one of his addresses to the nation, he said, don't think about what your country can do for you. Think about what you yourself can do for your country. And in that context, I am happy to say that we have founded the KANYEIHAMBA Foundation, which is now in the process of registration and has already opened the bank account in that name to perpetuate the spirit and the conduct of transparency, accountability, the rule of law, human rights, truth, and justice. On the lines of one of my books I have written, entitled In the Name of God, Truth and Justice, which is sold in all the major booksellers, bookshops, and certainly Stock, one of the leading seller of my publications. So that is by way of the KANYEIHAMBA. I have been presumably a jack of all trades and perhaps master of none. If you look at my record, it is this, what I have done and refused to do is in a book compiled by my good friends, including Margaret Businde, Derek Chionga, Mr. There are two others, including the publisher of many of my books, Michael Buembo, among others. They published a book, and they have called it KANYEIHAMBA the Incredible. KANYEIHAMBA the Incredible.
Yeah.
And that book is also available in the bookshops. And it lists my CV,
Yes.
the work I have done, and the work I have refused to do. And one of my refusals has made me be regarded as a controversial judge, and that is to succumb to the powers that be, including the presidency, on issues in which I believe they are wrong, or in principles I believe for good for this nation. So recently, I become one of the major critics of the president's campaign to abolish Mayoland in Uganda,
Yes,
because he doesn't understand that the 1900 agreement of Uganda has been transformed into a commercial enterprise, and many of the people, citizens who own Maryland in Uganda are not Baganda. I am one of them. I own Maryland in Uganda. The Busuru and the Mvujuro, which his minister, state minister of land seems to criticize, is a matter of history. I pay an ordinary reasonable rent annually of less than 1 million to the Buganda kingdom. If I wasn't a tenant of the Buganda Land Board, which the Minister of Lands today has said is illegal, I don't know why he says that.
Okay.
Because we shall discuss that.
Yes, Professor. Yes, Professor.
So the other one, I challenge it, and I was a victim of it, is challenging the removal of term limits and the age limit.
Yes, Professor.
I am still of the view that we made terrible mistakes in removing them, and I have complete evidence for that.
Professor.
And finally, I have opposed the abolition of the right to bail in serious criminal cases.
Yes, Professor, if I may interrupt.
Yes.
You've most of our theme today deals with constitutional law. It deals with the lessons for young lawyers, and you've listed some of the things that are on our list, some of the questions that we would wish to ask you, Professor. Professor, you've just given us a feedback looking at the history, looking from when we got independence up to now. And my question is, Professor, looking at the Uganda of 1962 and the Uganda of today, we are in the eve of our independence, and then the future of Uganda. What is your take? How do you see Uganda now from 1962, the Uganda today, and the future of Uganda, Professor?
As I say, we were declared a protectorate in 1894. Since then, we have had different leaders, different governors of different characters, until the eve of the 1960s, when we got the right of self-determination and self-governing. Then in 1962, we became independent. I don't regret that progress whatsoever. And since then, on the credit side, we have done extremely well. Our economy has improved tremendously. The standard of living has increased. We have made tarmac for many roads we have. During the colonial times, from Kampala to Kabale, it could take you a day, a whole day. Today, if you have a good car, it is a matter of hours. So this is progress. At the time, we had only one known university, Makerere University, the leading college in East Africa then. Then we acquired a tertiary university, rather a tertiary school called Chambogo, which later became a university. Today, almost every district has a university. That is progress. So we should not belittle that. That is on the credit side. But we have also had, unfortunately, the debit side, the side that should be regulated. On human rights, civil liberties, and democracy, rule of law, we have retrograded, and we are much worse than we were even in the colonial times. So the NRM government on this area of human rights, liberty, and the democracy is about the worst government we ever had. Even compared to those of other post-protectorate governments, even including that of Amin, although Amin excels in torture and the killings, but the NRM exceeds in nurturing the destruction of democracy, the rule of law, and human rights.
Professor,
Since the NRM came into power, many people have been killed, many citizens have been incinerated illegally, and some have disappeared. The investigations by the police have yielded no results, partly because those who perpetuate the offenses are either supporters or perpetuators of the same evil. That's what has happened. So it has been a mixed blessing since independence.
of both good and bad.
Yeah.
Thank you so much, Professor. You've highlighted issues of human rights and democracy. And I want to applaud you in a way that you don't just criticize, you can see the good things, and you've told them to students of law that, Professor, you see both sides. You've had the good side and the unfortunate parts, like he has highlighted. Now, Professor, being the chairperson, legal committee of when drafting the Constitution of 1995, do you think that the Constitution has achieved its objectives?
No, the Constitution has not achieved its objectives. It has been suppressed, retarded, avoided, and breached left to right by the NRM party, which sponsored it in the first place, and which its leader, President Museveni, when we promulgated the Constitution in 1995, stood up and publicly praised it under the Constituent Assembly and the people of Uganda for making the best constitution that Uganda has ever had. And he made a promise, which he has broken, that he will go to the bush once more if anyone ever tampers with that constitution. Little did we know that his party and he himself would be the first one to violate the provisions of the constitution.
Thank you so much.
Which has continued doing since the enactment of the controversial amendment of 2005, which we shall revisit later when I appeal to the whole nation through the Royal Societies that that constitution should be revisited by the 11th Parliament, led by the political parties which are in Parliament, including the NRM, to delete. Please write it down, and I want the people who are listening to me to write this.
Yes, Professor.
Delete paragraph A of subsection 6 of section 59 of the Presidential Elections Act of 2005, because that paragraph conflicts with Article 104 of the Constitution, conflicts. It is therefore null and void. It is intended to intimidate judges of the Supreme Court, and it has done so. In every petition, it has intimidated the judges. Consequently, they have come to the wrong decision. All the petitions we have had, 4 of them, since the promulgation of the Constitution, are questionable. The other decisions of the
Supreme Court
are questionable. And I'll tell you later why.
Well, Professor, thank you so much. You've highlighted the Constitutional Amendment Act of 2005, but is it the only way where the Constitution has been violated? I would like you to throw more light on certain instances or certain provisions that you think that have been violated.
But that is the most, shall we say, the most heinous and the scandalous amendment, not of the Constitution, but the insertion of Article A in the Constitution. It was a fraud on the people, because it is not even in the Constitution itself. It is not even in the 1995 Constitution. It stands on its own as a fraud on the Uganda nation. So it is the most scandalous of them all.
Thank you.
In order to get it, the NRM party corruptly paid members of MP who were willing to lend credibility to that act 5 million each. You people have forgotten. 5 million each. So the paragraph was obtained by fraud and corruption. So it is the most notorious. Then I appealed to the opposition, including reasonable members of the NRM, that on the first sitting of the 11th Parliament, which is now, they should move a motion moving that paragraph A of subsection 6 of section 59 of the Presidential Elections Act 2005 should be deleted.
Thank you so much
from the Constitution.
Thank you so much, Professor.
To add more fire to my view.
Yes, Professor.
Article 3 of the Constitution
Article 3, Professor.
provides that the Constitution of Uganda, that is 1995, is the supreme law of the country. And any other law, including paragraph A, subsection 6 of section 59 of the Presidential Election Act, is null and void. They are void because it conflicts with the provisions of the Constitution in Article 104. Having said that, it goes further. And they said that other law, in this case, paragraph A, clause 6, section 59, Presidential Elections Act 2005, is inconsistent with the Constitution, and therefore it should be deleted from the Constitution as a matter of urgency.
Thank you so much, Professor. As you said, it should be what? It should be deleted. Professor, apart from that, which is very vital and we've noted it, there is an ongoing concern about bail, Professor, where capital offenses, the president is saying that those people shouldn't be given bail. What is your take? Put into consideration of Article 28 of the Constitution of the Republic of Uganda, 1995.
Once again, I have taken issue, very serious issue with the president. I wrote an article which was published in Sunday Monitor in the year 2012, saying that the right to apply for bail, is a no-go area. It should never be affected. If we look at the provisions of the Constitution, there are certain rights and freedoms which are entrenched and are unalterable forever. One of them is freedom from slavery, forced labor. The other one is the right to be heard, and the right which is connected with the habeas corpus.
Yes, sir.
Is the right to apply for bail if you are illegally or even lawfully detained, but the court has not proved that you are guilty. It is connected with the other principles of Ugandan law. One of them is the presumption of innocence.
Yes, Professor.
In Uganda, under our system, everyone is presumed to be innocent until proven guilty by a court of competent jurisdiction, which in this case would be the High Court or something higher.
High Court, Court of Appeal, and the Supreme Court.
What Museveni is telling us, and the caucus has not spoken, what Museveni is telling us is that we should adopt a principle where whoever accuses you of a serious crime, however wild, however unjustified it is, you should be proved guilty. Rather, you should be presumed guilty unless you prove yourself innocent. This is a communist. Most communist countries have even dropped that. So Museveni wants to go back to the pre-1960s system of communism. When you see there is allegation of theft against Mr. X, you shoot Mr. X, kill him, and ask questions afterwards. This is very dangerous.
Very, very dangerous because we've read different decisions in Supreme Court, different decisions in
Let
court.
me justify my concern.
Yes,
further.
Professor. Yes, Professor.
The statistics show,
Mm.
first of all, that our police are very corrupt. And that one has been confirmed by President Museveni himself. When recently he said the police are the most corrupt institution in Uganda. Now you entrust that to arrest suspects. Many of the cases we have found, people were framed because they had refused to pay some money to the police, or the police had a grudge against their relative or whoever. So most of the suspects called are later acquitted of the offenses they committed. The majority. Now he's saying that all those who are accused of these serious crimes, killing, murder, treason, aggravated robbery, and assault, they should not get bail. Museveni was at one time regarded as a bandit. He was challenging a duly constituted and validly elected government of Milton Obote. Who won the election without very much accusation of corruption. Every election that Museveni has won after 1996 is flouted with allegations of corruption, abuse of office, frustration of his members, and bribery. The majority of the petitioners in 2021 presidential elections and parliamentary elections are members of the NRM party. They have alleged that the system
It's corrupt.
cheated them, was preferable. There was a lot of buying of votes. I mentioned one who is a minister now, and she told me that she had to belong to NRM, although she's not, although she's DP, because if she didn't have money to pay for being elected. And secondly, many of her constituencies were given money to vote for NRM, and they wouldn't win. Now, this is the kind of environment under which suspects are arrested and detained. Therefore, it is imperative that their innocence should be presumed. We should be able to say, but that policeman is corrupt.
True.
Or he wanted the 50,000 shillings. That's why he arrested this person. Therefore, President Museveni is so wrong to oppose the right to be granted bail. Now let's take him. Obote and the UPC regarded him as a rebel. I supported him when he was in the UK. The group I led in the UK, in exile, was known as the Uganda Group for Human Rights. We put our full support to Museveni when he was in the bush. I helped for him to get sanctuary in Sweden. And when his wife was not well, we arranged for her upkeep in a hospital in London. They seem to have forgotten all that. But saying that, supposing he had been captured by Obote and his forces, they were looking for him. And at the time, those who supported Obote and the UPC, they regarded him as a dangerous criminal at large. Supposing they had arrested him, captured him, and Obote was still in power, he would, according to him, he would still be in jail without bail. Many of his supporters escaped, went into the bush, went into exile. Many of those who were caught, especially during Idi Amin's regime, sadly were executed. We shall never know their fate. Has himself forgotten that history? But more importantly today,
Yes, Prophet.
everybody who is who in Uganda, the law society, judges, the Chief Justice, the students, and everybody say, including very many supporters of the NRM who are members of parliament, have said, sir, the law about bail was settled long time ago by the Constituent Assembly. And the lawyers who numbered over 20 delegates were together, chaired by KANYEIHAMBA and Benjamin Ben Wacha, who was my deputy in the legal and drafting committee, and we don't want to visit it. And Odochi carried out research and inquiries about what kind of constitution we should have for 4 years. Then they took the Constituent Assembly another 2 years to discuss and make the constitution. The Constituent Assembly was widely represented. The Constituent Assembly widely represented the Uganda society. We had the smaller constituencies of Constitutional Assembly than we had of Parliament. Even that was settled under the 1995 Constitution. And we put in the right to apply for bail is absolute. In order to mitigate,
Yes, mitigate.
we also said the court shall have discretion whether to grant bail or not. And most courts are reasonable. And they are Ugandan led. So they will not make decisions which are arbitrary, which are unduly harsh. And if they judge, in their opinion, they are lawyers, that you deserve bail, you have bail. But if they think you are a dangerous man, you shouldn't be at large, they refuse you bail. And this is our system. It has happened from time since we were independent. And that is the correct way to do things. Now Museveni is becoming a judge also. Maybe you ask me later if we have time. We put in the Constitution, Museveni has no powers to nominate anybody as a judge. That is the role of the Judicial Service Commission. But these days, the Constitution has been ignored, and Museveni is nominating judges. And we keep quiet to Ugandans. I don't know what's the problem with us. You hear Museveni has appointed so and so a judge. He has appointed so and so deputy chief justice. The deputy justice, Richard Butera, under the chief justice, are friends of mine. And before they became what they are, we used to talk, sometimes to dine together. I went to the chief justice was properly nominated by the Judicial Service Commission. But I don't remember Deputy Chief Justice Butera Richard being nominated by the Judicial Service Commission to be Deputy Chief Justice. But Museveni simply announced he has been appointed Deputy Chief Justice. So I would like, if Butera is listening to me, were you approved by the Judicial Service Commission? Because even today, he was in the newspaper, the Deputy Chief Justice. How can you be Deputy Chief Justice if you are a lawyer? You have been DPP. I used to interact with him. We had dinner together when I was Minister of Commerce and he was DPP. And you don't ask the president to tell him, but sir, I have not been approved by the Judicial Service Commission. Or say, Mr. President, like in the case of Odochi, being renominated to become Chief Justice again when he had already retired. You tell the president, but Your Excellency, I am not qualified. I have retired, I'm 70 years old. But you agree to be reappointed again, Chief Justice, knowing you have retired.
Professor. Thank you so much, Professor. Professor has told us that the right to bail is absolute. And Professor has also gone ahead to hint on things like the judiciary has told you that it's the Judicial Service Commission. And in as far as we know, that is the law. But Professor, there is a reason why you emphasize that. What are the consequences of such scenarios where the judge is appointed by the president? Could it be the reasons why we might, because as my understanding of constitutional law, as you stipulated in most of your writing, that we have different arms of government.
Yes, we do.
We have the judiciary, the executive, and the legislature, Professor. So do you think that if the president goes ahead to appoint judges and the Judicial Service Commission, I think it approves, do you think that one has consequences on the independence of the judiciary?
The function, I want to call it a function, not a power. The function of the president to appoint ministers, judges, ambassadors, permanent secretaries, is a constitutional function which is mandatory. He must exercise it. But it is also mandatory and very imperative that he cannot appoint anybody whom he wants. He passes through the recommending authority. In the case of ministers, yes, he does nomination, but Parliament must approve before he appoints. So there are two stages. He nominates candidates for ministerial appointment, and then they may be members of Parliament or not members of Parliament. But whether they are members of Parliament or not, Parliament has the duty to approve them. You know, recently, when Parliament was exercising this function, they rejected one of the candidates, Minister Kabayu. Then later on, I think there was an appeal from the others, her relatives and other friends, and the Parliament changed its mind, or was forced to change its mind, and reappointed her minister, which again is very peculiar and is only available in Uganda under the NRM. With the judges, let's look at the last time it was the Judicial Service Commission made the decision. I was a candidate at the same time with the late Justice Mulenga, with Justice Arach Amoko, who is now in the Supreme Court, the late Justice Twinomuvuni, I can't remember, there were two others, and we appeared before the Judicial Service Commission. When people knew, I was nominated by President Museveni to appear before the Judicial Service Commission, not to be a judge, but say KANYEIHAMBA would be a suitable judge. So Mulenga, KANYEIHAMBA, Twinomuvuni, Arach, we were nominated for Arach to become a judge of the High Court, for Twinomuvuni to become a judge of the Court of Appeal, Justice Mulenga and I to become judges of the Supreme Court. So Museveni informally told, I have never applied for office, ever, not in Uganda. So I was told, Museveni said he wanted a Catholic minister from Kigezi, from Kabale, who was an NRM, to replace me, because there were too many Protestants from Kigezi being ministers. And he told the people of Kigezi who supported the Catholic man, the candidate, that if they elect a Catholic, he will make him minister. These are the politics of, I don't know what to call them, a chance. Then he called me, that he wanted me. I had already decided not to stand for parliament, because I promised in the Constituent Assembly that those who made a resolution, that those of us who are making the Constitution should not stand for the next parliament. That way would be independent and not exit for our personal interest. And a minority of us obeyed that decision, but we were overruled by the majority in CA. So they didn't bar the delegates who made the Constitution from becoming parliament in the first parliament. But for me, I didn't. And I was going to practice. So when I was preparing to practice, Museveni called me and said he wanted me to be judge of the Supreme Court, because he had assessed the situation in Kigezi, in my constituency, and only Catholic would win. I am a Protestant, but people in Kabale laugh because I am non-religious. I don't use politics or religion or tribe to be anything. And therefore, he said, you stand down and we shall have a Catholic candidate in your place. And they chose my friend, Dr. Edel Gwendele, he's a pastor now, to replace me. There were other candidates, but he won. And as Museveni promised, he made him a minister. But Gwendele didn't like the portfolio they gave him. Eventually, he resigned and applied for an international job. Be that as it may, when they nominated us, we appeared before the Judicial Service Commission. Yes. All of us. We were interviewed by the Judicial Commission at our time led or chaired. The chairman was Justice Benjamin Odochi. He interviewed us. You read it in The Blessing and the Job, who you are. What role Catholic they play at that time. Because he had also become Minister of Justice and Attorney General, replacing Abu Mayanja. Anyway, be that may, we were interviewed. The press was present to show transparency. And I remember the editor of the government paper, New Vision. He was called William Pike. William Pike, remember? Was the general editor of New Vision, a Muzungu, whom we had recruited from the UK. He wrote an editorial saying, Dr. George Kanyihamba and Mr. Joseph Mlenga are excellent men of impeccable character. But he questioned our qualification to become judges. He said, but they are politicians. Mlenga was the vice president of DP, and I was what Museveni called my troubleshooter and the pillar of the NRM. So Pike, William Pike, wrote an editorial questioning our impartiality and the qualification to be judges. But if you do at the history of Uganda, Mulenga and I became judges of Supreme Court, maybe for the next 10 or 11 years. And if you look at the history of Uganda, we were some of the best judges Uganda has ever had.
Yes, Professor, I agree with that.
So the point I was trying to make very seriously is these days, you hear Museveni has appointed XYZ as judges of the Court of Appeal or as judges of the High Court, without any reference to the Judicial Service Commission has approved the candidature of so and so to be judges of the Court of Appeal or the Supreme Court. It is only when the Judicial Service Commission has nominated and interviewed suitable candidates that they forward the names to the president or the name for appointment. And the formula is in accordance with the provisions of Article 2 and 2 of the Constitution. And on the advice of the Judicial Service Commission, I appoint Kanyihamba judge of the Supreme Court, or I appoint Odochi as Chief Justice of Uganda. And each judge must have a separate instrument of appointment. Museveni in these days, he can nominate on one instrument 2 or 3 judges because he has not been advised about the Constitution. In fact, in the case of Bat Katurere and as Chief Justice, and Stephen Kavuma as the Deputy Chief Justice, I challenged the appointment of both of them privately because they were appointed on the same instrument. He wrote with the powers entrusted with me, without citing the relevant article, and in consultation with, not on the advice of, in consultation with the Judicial Service Commission, I appoint 1, Bat Katurere, 2, I appoint Bat Katurere, Chief Justice, and 2, Stephen Kavuma, Deputy Chief Justice. Totally wrong and constitutional, because the formula of appointing judges we put in the Constitution. They cannot deny that because I have a copy of that document. Somebody in the judiciary, when they issued them, he was so incensed, but he would not say anything. So he sent me a copy. I keep it.
Professor, may I interrupt? Thank you so much, Professor, for sharing with us. Our participants, we thank you so much for joining us. This is UC Law Society Eminent Speaker Series, and this is our last one. Please keep the questions coming, and we shall. I will give them to Professor.
But can I finish on bail?
Yes, Professor.
Museveni cannot invoke his authority to move the NRM at the caucus to amend the provisions of the Constitution on bail, because the caucus is not the authority to do so. Museveni may have 90% of them supporting the NRM party. He can even have 100% supporting the NRM. But they are not the parliament of Uganda. They represent not the movement in parliament, but the geographical constituencies and the special groups. So they can only act in accordance with the wishes of their constituencies collectively, and not the orders or directives of the party or Museveni. I have established a number of legal principles in Uganda as a judge and a lawyer. I represented the so-called rebels, NRM rebels, Sechkubo
And others.
and the others. And I got the judgment in their favor in the Supreme Court, which said an MP represents a geographic constituency or his special party, like a women's group,
These
soldiers
people with
group,
disabilities.
workers, but does not represent a political party in the parliament. Parties may sponsor candidates, and that candidate may have sympathy with the leadership of the party. But in the parliament, they represent geographical constituencies. Secondly, their responsibility is to the whole nation of Uganda, Article 59, and not to the constitution of the political party. So that is one important and fundamental restriction on the powers of the president. Second one is that since Uganda was called a protectorate, that is a separate country, in 1894, when we were declared a protectorate, we have been signatories or members of international conventions and treaties,
Yes,
including those of the OAU. Let's have a small break and I drink water, and then we continue. Just 2 minutes.
Well, thank you so much, our participants. Let's have a break. We're going to come back to you in a few minutes. Please keep your questions coming. Keep your questions coming. Professor is ready to answer them. Yes, this is our eminent speaker series, and today we are. Yes, thank you so much for the call, for participating in today's eminent speaker series. Wherever you're coming from, our participants from different universities, we are glad to have you on the call. This event is sponsored by Council Bernard Oredo, President East African Law Society. Thank you so much for your support. Well, there are so many issues that Professor has talked about, and we keep the questions coming. He is going to answer them. Yes, we also have. Yes, today we also moved. We have our colleagues that have just joined us today. We have part or one of our new entrants today with us, and they all came with us today at Professor's place. Young ones, we understand that you have started the semester and you've been oriented today. We want to welcome you. This is Uganda Christian University, particularly Uganda Christian University Law Society. You just pay subscription fee of 50,000 and you become a member, and that comes with various benefits like mentorship. We usually have our mentorship program. We usually have we guide you through law school. We don't leave you alone from the beginning to the end. That's why we keep on looking for knowledge. And today we are at Professor George W.KANYEIHAMBA.
W stands for Wilson.
Yes, W stands for Wilson. Yes, he's a retired Supreme Court.
I am a judge. Who told you I am retired? I am not working in the courts, but I have never retired.
Yes, Professor.
Why do you people emphasize retired? What value does it add? That's what I'm saying. Nothing at all. I am Justice Kanyehamba. But retired. Don't you know how people say, since he's retired, he has nothing to say?
No, Professor, some people say he's retired, but not tired. But
then why do you say retired? He's not retired.
Apologies.
Let's
Professor.
go ahead.
Thank you so much.
It's not, I am not annoyed, but
No.
I am amused.
No, Professor.
Retired. Newspapers. Why is it necessary?
No, it's
Do
not.
we ever call doctor? When you call doctor, you say retired doctor.
No.
Emphasizing retired. Why? My brother. You are using common language. I was going to ask your audience, let them think about it.
Okay.
When I became a minister first time, somebody called Mrs. Museveni, Janet. I have always called her Mrs. or Honorable. But these days, she's Minister of Education. They continue calling her the First Lady. Why? I am asking everybody who's listening to you to debate this matter. Why do you call the Minister of Education First Lady? Why? Why not Minister? Honorable. Because they call her First Lady to inject fear in anybody going to question. You are asking the president's wife. Why? But a wife and the First Lady is connected with the bedroom. Nothing to do with the philosophy of the education. And when I called her, I have never called her First Lady. She thanked me. I tell reporters, but they continue calling her First Lady. But I had a letter from her, which I could publish if I wanted to, thanking me for not calling her First Lady, but for recognizing her in her own right as honorable. That is Janet Museveni. And until she advises me otherwise in writing, I will always call her Honorable or Mrs. Museveni, because that is what she is. She's a minister. Whatever she's doing, when she was Minister of Karamoja, whatever she does, she did it not because she was sleeping with the president, but because she's qualified in her own right. Thank you. Go on.
Thank you so much, Professor.
So if you say Justice Kanyehamba, you shorten your words, and there's no need to say retired justice, retired. Because they will ask you, why are you giving us information from a retired man?
Thank you so much, Professor. Professor is not retired. Professor is active, and it's the reason we are here today with him, because he has a lot to share with us.
And I have written, now I am on my 34th book. It is going to be published. The other one, the manuscript is here. It is called African Jurisprudence, the Power of Africa. Nothing is predictable.
Thank you so much, Professor. Professor.
So I'm still working, not retired.
Yeah, exactly, Professor. And you even donated for us a book, which I will talk about later.
Okay.
Well, Professor, there's one of the participants, they have questions, and one of the questions is from Kamukama Darius. And the question is, what challenges did you encounter in the dispensation of justice in your tenure? as a Supreme Court judge?
There were not many, but there is one great. I have never regretted in my life what I do conscientiously. But in one case where we were 5 judges of the Supreme Court, the late Justice Sekoko wrote the judgment of the court. Because in criminal cases, the Chief Justice always puts one judge who drafts the judgment, then the others agree with him. There are hardly ever any dissent on criminal cases. There are obvious reasons. When you are saying we are sentenced to death, nobody should say you are not sentenced to death because it will create a lot of problems. So you always convince your colleagues that either you allow the appeal or you dismiss it, and usually it is everybody signing the judgment. However, if there is a division in the court on criminal case, normally, if the Chief Justice is wise, you don't allow dissenting judgments in criminal cases. You give the accused the benefit of the doubt, and not normally, unless there is a majority to convict, you exonerate the accused, or if it was capital murder, you reduce it to manslaughter, things like that. But I'm going to the mechanics of it. However, in that case, the High Court convicted the man and his son of murder. And that is why it is very important people should get bail. And I used to be of the view that capital punishment was all right for people who are convicted of capital offenses. But in my old age, I now doubt whether I was right. I think we should adopt a civilized way, say you can be sentenced to life imprisonment and you be interned without option for the most serious murders. But I think we should not put people to death, as my example is going to show. The evidence was clear. The man and his son, they lived in the same village. And one night, a person in the village raised an alarm. This is the evidence you see in court. And when everybody came from the village, they caught the 2 of them red-handed. And they tied them, and they took them to the police. The police, this time innocently, charged both of them as suspect murderers. When they went to the High Court, the inexperienced judge simply didn't examine all the evidence, and he convicted them for murder and sentenced them to death. The case went to the Court of Appeal. It was a very busy session. They gave it to a judge, but because he had another important case, he browsed through and said, I think the judge is right. Confirmed the judgment of murder and conviction, rather sentence of death. The case came to us before me. I was the only member of the panel. We were 5. Justice Sekoko, Justice Karokora, Justice Odochi, and Justice Mulenga. It was a busy session also for us because Ben Odochi had a policy that we shouldn't have any alias. He's finished the case. He was, in that case, a very well managed case load. So Sekoko, I think, in my opinion, he did not read the file very carefully. He tended to believe the courts below. So he confirmed sentence of death to the two. And for me, I'm in habit, even if I have approved. Then I signed the judgment of Sekoko, because in criminal cases, you don't write different judgments unless you are really dissenting. So I signed. Then later I had the time, because when I had to finish, I sent the file to Sekoko. Eventually, we were summoned to deliver judgment. As we waited for judgment, I read through the file. First time I had a time. I wanted these people to hear that these things happen in real life. Then I had a doubt, because there was one common feature. On that night, it rained. When they are alleged to have broken into the victim's house, it was raining. There was mud everywhere in the compound of that pass. It was in the village. But when the police went to their homes to arrest them on information received, they found them both in their respective beds. But there was no mud on their shoes. There was no mud. The shoes were dry. There was no footprint anywhere. So I said, my goodness, these people were wrongly convicted. They couldn't have done it, run home, clean their shoes, put their dust, and then slept. So I immediately went to see the Chief Justice. He called the meeting. I was very vivid. I said, Kanyehamba, trying to bring British justice. The point of the matter was, they said, we made a mistake, but it's too late to do anything about it. Then I was not satisfied with that. There was a religious cleric, Father Agostini or somebody, who was campaigning nationally to abolish capital punishment. I went to him with the file. I said, I think there was miscarriage of justice in this case. And I described to him, and he told me, I will handle it. I wrote to the president. I said, I think they should be given mercy, even if the courts don't do anything. The president has never responded to my letter, but I wrote to him. And I know the letter was delivered in the State House, then in Entebbe. Then father died. Then I continued reminding my colleagues that we performed the injustice in this case. I think we should do something about it. I even saw a representative from a policeman from Bunyoro. They was from Bunyoro. I said, if you know this village, I had forgotten to know the names, ask whether any of their relatives was ever convicted of murder and sentenced to death, and together we appeal to the president to exercise the prerogative of mercy. Up to now, I have never heard that from anybody, from not even the president's secretary, and it has bothered me. That's the only one mistake in my life. I condoned, if you can say wholly, and it has lived with me all this time. I hope that Museveni was not in the habit of signing death warrants, and if anybody is hearing me, including their MP, he should ask for the president to forgive them, and they should be compensated for all this time. If I told me they are still alive, they have been imprisoned, when in my opinion, they were innocent. He was the chairman of the LC in the area. Further evidence showed that he was a very strict LC chairman. He used to report people for not having outside toilet, for that, for children not going to school. And I think the village conspired to have them convicted of crime. But all this I learned later. Okay.
Thank you so much, Professor, for sharing with us. And one thing I know about you is that you always tell the truth, and you've heard the truth. In as much as they are at the temple of justice, there are some mistakes that happen, and Professor has shared with us one of them. Well, Professor, I have another question. It's coming from Muhanji. He's asking that when is the right to a fair hearing, as provided for under the Constitution, deroged? In one of our judgments, you stated, in one of your judgments, you stated that in summary dismissal of an employee, a fair hearing is not what? Is not afforded.
I wish she could give me that copy with judgment. I could say that in an employment to withdraw your labor is a right.
To dismiss.
Yes, and the right of the employer to say you're no longer necessary for me is also correct. But you must be heard. You can't. I have never, not even in a dream, said that the right to be heard should be compromised. I would be stupid, and I would be contradicting myself, considering that I am Mr. Human Rights. And when I was nominated to be a judge, the only reason they nominated me is because I am a human rights activist, and I have never been a military or political activist, but a human rights activist. So it would be a contradiction in terms that I could be a party to the judgment, saying it is okay not to be heard. To say you have lost the case as an employee for a different reason, that is possible. But to say you have no right to be heard, Ruth, that is not correct. It's not me. But she may be mistaking it with my lead judgment in the case of David Atinyefuza versus the Attorney General. In that case, General Tinyefuza had appeared before parliamentary committee, castigated the UPADF, saying he has lost confidence in Museveni and the UPDF, and he wanted to resign, but Museveni is refusing to resign. He challenged the Museveni's decision not to allow him to resign in the Court of Appeal, which is the Constitutional Court. And I think it was a unanimous decision. The court said he was right to challenge the presidential refusal, and he could leave the army whenever he wants as a right of the individual to withdraw labor. The case was appealed to the Supreme Court, where the Chief Justice, then Chief Justice Wambuzi, asked me to draft the lead judgment. Justice Wambuzi and the Justice Sokokwa, I served under both Chief Justices, and to give them their due respect, they always respected me and respected my view as a constitutional law expert. So, although I was a junior judge, he entrusted me with the responsibility of writing the lead judgment in Tinyefuza. I drafted it to the best of my ability. And that's a judgment, with one or two others I'm going to mention, is a leading authority on the relationship between the army and the people and the commandant. It is a leading authority. And if you read it, we were all 7. It was a constitutional code. Everybody, including the Chief Justice, wanted to say, we have read Kanyihamba's draft judgment, and we were in agreement. It was a majority judgment, because I remember Justice Mukasa Chikonyogo, she was still in the Supreme Court before she became Deputy Chief Justice. And I believe Mulenga dissented. So they have a dissenting judgment saying he should be allowed to leave the army whenever he wants, because it is his right as a citizen. In my judgment, I said no. A soldier has the primary duty of defending Uganda and its territorial integrity. And all the commissioned officers have a commission. You make an agreement with the UPDF leadership, signed by the president, that you will serve the army for 9 years or 5 years, as the case may be. And therefore, it is a contract between you and the people of Uganda. At the same time, Uganda may be facing an enemy, a vicious enemy, like Konye and some other bandit. And we need the army as a nation. That's why we give you a contract to serve. We give you what you require. We give you arms. We pay you. We house you in the barracks in order to fulfill your contract. And therefore, you can't just be allowed that the soldier say, I am leaving tomorrow. I am withdrawing my labor. Because you have a primary duty of defending this country. That is the substance of my judgment in the Tinyefuza case versus the Attorney General. And therefore, I convinced my colleagues to dismiss, to dismiss the appeal, which had been confirmed by the High Court and the Court of Appeal. Let me tell you, it was very tense waiting of the day, waiting for our judgment. I don't know what Museveni feared, but they feared that Museveni could carry out a coup. Or he had summoned overseas forces to come and overthrow Museveni. Because we read our judgment from 9 o'clock, 9:30, until 8 o'clock in the evening. They are the longest judgments you can find. By the time our junior judge finished, the junior judge then was Mukasa Chikonyogo. When we finished, everybody was very tired. And the president was very, very, very relieved. They sent the army with trucks to accompany us to our residences. From Mengo, where the Supreme Court was, an army jeep with armed police. Although I had my own police security, they accompanied me to here. And they only left when my gates closed. And they did the same with every judge. So it was a very tense. Then comes the invasion of the High Court by the Black Mamba.
Yes, Professor.
And no, let me finish this.
Yes, Professor.
At that meeting, President Museveni apologized. He called the judiciary, all of us judges, went to State House Nakasero, led by the Chief Justice, then Odochi, and apologized to judiciary. And they said the arrest of suspects who have been released on bail by the court was indiscipline on part of the security. It will never happen again in Uganda. And then Museveni quoted the KANYEIHAMBA. He said the relationship between the executive and the courts was settled long time ago by Justice KANYEIHAMBA. But those are the words from Museveni. By Justice KANYEIHAMBA in the case of Tinyefuza was the Attorney General. He quoted me at State House. So he said, therefore, I have no problem recognizing the function of the court and my own role in the nation. We clapped. They gave us some cakes, all of us, to see that he has forgotten that statement. I want this social media, your record. Maybe he can hear it. Somebody can tell him that, have you forgotten the Black Mamba? And what happened? It was intense atmosphere. The late Prime Minister, Professor Apollo Simbambi, called all of us to his house when Museveni was not there. The Minister of Internal Affairs was Nduguru Hakana Rukunda. The Prime Minister was Kamama. I note today was headline in the Monitor that he has been made presidential advisor of some kind. But so they are emphasized that the post is personal to him. So there will never be another. Just as I was the only senior presidential advisor, the first one, and the last one on human rights, international affairs. And when I became a judge, the post was abolished. There you are. That's what happened.
Thank you so much, Professor. One of the things that I'm not obliged about being here is the fact that you're getting information from first hand. Students of law, Professor, in year one, and more especially year two, when you talk about the rule of law, or even up to now, we cannot forget the Black Mamba incident. But we read about it in newspapers. We heard about it. Lecturers told us about it, but we've heard from the judge about the entire incident. Therefore, I expect that young ones that are on the floor, you will be able to get that right when you begin studying constitutional history and constitutional law. Thank you so much.
A point on that one.
Yes, Professor.
The principal judge whose court was invaded was none other than James Ogola.
James Ogola.
And when the High Court was invaded, he was with us when we negotiated for apology from the government in the office of the Prime Minister, Apollo Zimbabwe. But he said words which should be memorable. And I want the students to remember them. I remember them.
Yes, Professor.
He said, when the Black Mambas invaded the High Court, it was similar to invading the temple of justice. I have never forgotten those words. James Ogola. The incident was the rape and the invasion of the temple of justice. That should be remembered. Thank you.
Thank you so much. Hope everyone has been able to note down the emphasis that the judge has made to us. Well, there is another question that I didn't get the name, but the question is, Is there a possibility of justices in the Supreme Court being compromised by the executive or clients in high-profile cases that attract a lot of public attention and interest?
You know why I'm laughing?
No,
I
Professor.
don't know why the question asked that. It's quite evident that most of our judges are cadres, not of the justice, but of the NRM party and its leadership. They pander to the president. Before they give judgment, they ponder, will this please the president? Or Fondo? We have ceased to have independent-minded judges. There are few people like Kakuru who are still left there. I believe, I don't know, people like Justice Monda. I may disagree with her on her approach to constitutionalism, but I think I even reported her for incompetence. I'm sorry to say, in one case. I believe people like Reme Kasule, people like Engonda Ntende, people like Jeffrey Shidabwide, I don't have any evidence of wrongdoing. But if I tell you how Shidabwide became a judge of the East African Court when he was handling our case competently, it shows you what can happen. Just before he finished our judgment, in the case of KANYEIHAMBA, 320 other shareholders versus Nzei, Amos Nzei, and Mama Mbabasi, he had given a very good ruling in our favor. And the powers that be seem to have been sympathetic to Nzei. So they promoted him to the Court of Appeal. He was the judge of the High Court, and also nominated him to the judge of the East African Court. In most cases, judges are allowed to complete the cases they started in the court from which they have been promoted. For him, he was not allowed. They appointed another judge who was compromised. His judgment, we appealed against it, and then they brought to the appeal, and the compromised judge, so it disappeared. Eventually, the Kigezi Bank of Commerce was compulsorily given to Kuleni Bank, and the case is in court. So I don't want to go any further to sub judice. But the point I was making, answering that question, is for me, I have no doubt whatsoever that many of our judges, if not most, are cadres of the movement. And to prove visibly that's true, recently, you know, we get our judges mainly from members of the Law Society.
Yes.
During the election of one president of the Law Society, who is now a member of the Judicial Service Commission, Sebutindra, it is President Museveni and the NRM which interfered and facilitated those who were going to vote for her. I was there. She was eventually nominated and is a member of the Judicial Service Commission, number one. Number two, only a few weeks ago, he was shown on TV, she was shown on TV, that the current president of the Law Society, I think the lady,
Yes.
was seen going to see Museveni wearing NRM party uniform. the president of the Uganda Law Society. And what have you done? For you are not lawyers, you're a student. What has any lawyers or any professors said about it? Nothing. They have been silenced. So one of the mottos adopted by the KANYEIHAMBA Foundation is there is nothing as evil as political fear. When you fear a person or a party like NRA, you have hallucinations of being killed. You don't sleep, and you are told to do certain things, even if you are a judge. The other damaging liability is ignorance. If you want to govern a people without much challenge, keep them ignorant. As a result, our educational standards are promulgated at the bottom. People like KANYEIHAMBA, people like Kasozi, Professor Kasozi, people like the former Executive Secretary of the National Council for Higher Education, we are not consulted. There was an association of Uganda vice chancellors, I don't know if it is there, vice chancellors of Uganda universities. I was one of those who were asked to address them in a keynote address. When I sent it, Alupo was the Minister of Education. She commended me. She even came to cover the university. And I took her around with the vice chancellor. And I think she would have made a good and a more effective prime minister than the present one. She could have been a better prime minister. I think she was silenced by beginning the role of vice president, which is very bad. But I don't want to comment on politics. Then I gave a copy of my speech to the new minister, who I used to admire tremendously, and that is Honorable Janet Museveni. I congratulated her, sent her a copy of my speech on education, which was a keynote address during the period Arupo was minister. Janet has never answered my letter. She has never, since she became Minister of Education, called me, even to greet me, let alone to hear my view on education. But what is being done in the name of government is spend millions of shillings, publishing every result in every school, whether good or bad, and saying the ministry is doing extremely well. It is not. Education standards have promulgated down, but nobody wants to recognize that. Thank you.
Thank you so much, Professor. We're almost time bad. But Professor, the last time, the first time I was here, you talked about lawyers, I remember. And you told me that you young lawyers nowadays, when you're writing, what's wrong with you when you're writing your arguments, why aren't you brief, accurate, to the point? So, Professor, I'm requesting you to give some few ideas to students of law on the call today, some few tips that they should take so that they remember that Professor KANYEIHAMBA told me this for a successful career.
I want my former lecturer who was teaching us the philosophy of law and jurisprudence is none other than many of you know in the books, Justice Denning of UK.
Yes.
When I went there as a student, he was one of our lecturers, but he was a practicing judge. Even those who study land law, we were taught by Megari, famous land law writer.
Okay.
And we used his textbook, just as you today, you are using KANYEIHAMBA's writings as reference books. And he told us that in the old days, lawyers used to charge and be paid by the length of their submission. This is all Denning speaking, but
Yes.
what he told us.
Yes,
He
Professor.
said, in one case, Mr. Jones versus Mr. Blog, he used pseudonyms. The lawyer was instructed to write a simple will to his client of 1 page or so, which should have taken a short time. Then, in those days, you were paid by the length of your document, which you have trusted for your client. The words, the more words you used, bombastic words, the more you were paid or charged. So the lawyer drafted. He had bought a house, was 1,000 guineas. And when he counted the words of the will he had made, they came to 800 words, rather 800 pounds, which was 200 less than what he wanted. So he said, how do I lengthen this document? So he invented an interpretation of the will. And he said, in this way, unless otherwise the context provides, clause 1 means clause 1. 2, clause 2 means clause 2. 3, clause 4 means clause 4. Up to clause 10, there were 10 clauses. When he counted the words again, there were still 10 words less than what he wanted. So he said, what do I do? So he said, in this will, then he said about 10. Section 15 of the Constitutional Act does not apply. Interpretation 2. The 19 agreement of Uganda does not apply to this will. Until he got those and got 1,000 guineas. And then he sent the bill to his client, I want $1,000. I have seen similar lawyers' bills, lengthened on such and such a day, telephone conversation, 15 minutes, such and so. No, you can't believe it. Now, I'm glad you mentioned that. 2 days ago,
Yes, Professor.
I took out booksellers, which are friends of mine, said this book, case book on lawyers' ethics, professional fees, and the charges, they were selling it, it's finished. I originally gave them 100 copies. So yesterday they asked for another 20
copies.
I happen to have them here. They were delivered yesterday. And I would like to say, if you have the money, please get a copy. They are available in all the bookshops, particularly in ASO. and I think they quote 50,000 shillings. They should not charge you anymore because I am the one who fixes the price in accordance with what I have spent producing it. And the 50 includes the charges of the bookseller. So if the book price is written here, $50,000. Most of my books, except that the evolution, are 50,000. One of them is the 30. That is the one on jokes. I have that one also. Then this one of presidential election is only 20,000 because it was subsidized by a politician of the NRA. So the only expensive book in the bookshops, 100,000 shillings, is Evolution of Constitutional Law, public law and the government. But having said that, I want
to give us some lessons.
In relation to what you read, I want you to read here, this book. I want you to read the two things. They are short.
Okay, Professor.
One is my introduction, the first paragraph, and the other one is what W.KANYEIHAMBA says about the Prime Minister. Here, it was also reviewed by Professor Tamakere, but we don't worry about that one. I want you to read for our listeners the first paragraph of the introduction, and then what W.KANYEIHAMBA says in the preface. I think it's here. This is the introduction.
I read the first paragraph?
Yes.
I'm reading the first paragraph of Professor's book. It's called Case Book on Lawyers, Ethics, Professional Fees and Charges. Professor Dr. W.KANYEIHAMBA. He has told me to read paragraph 1 of the book, the introduction. It says that this book will not be welcomed by dishonest lawyers or greedy litigants. It will not comfort the corrupt and collaborators in crime, nor will it bring solace to the court officials, taxing masters, judicial officers, or judges who participate in or condone the legal racket of overcharging excessive legal fees, whether in litigation or disputes settled out of court.
That's very short. Then it was, the preface was written by Honorable Hakana, then Prime Minister of Uganda. He read the manuscript, and this is what he wrote here. Is he there? That's Ghana. Was the professor from Makere? But who is that?
He's the one. He's the one.
Is Hakana?
Yes.
Read it.
Should I read the last
yes,
one?
No, read the whole.
Okay.
It is short.
I'm reading something from the preface by Right Honorable Dr. W.KANYEIHAMBA, Prime Minister of the Republic of Uganda. I had the privilege of reading in draft Professor W.KANYEIHAMBA's casebook on lawyers' ethics, professional fees, and charges. It is an absorbing, instructive collection of cases, amplified by Professor KANYEIHAMBA's own remarks and opinions as former Minister of Commerce, Minister of Justice, Attorney General, first and only senior presidential advisor on human and people's rights and international affairs, Justice of Supreme Court of Uganda, African Court on Human and People's Rights, and Senior Counsel. Its major part contains rulings and decisions of justices of Uganda Supreme Court, of which he was a member for more than 12 years. The remarkable phenomenon of this book is the glaring difference between the astronomical costs demanded by lawyers, approved or marginally modified by taxing masters, and the greatly reduced costs awarded by judges on appeal. As leader of government business, I find this book highly relevant because of my knowledge that government pays colossal sums of money in courts in cases it could easily have won or cheaply settled out of court. Yet government lawyers perhaps compromise, succumb to temptations, and consent to or fail to oppose exorbitant fees and cost demands demanded by lawyers, which are readily accepted by taxing masters, oblivious to national interests. I highly recommend this book to the public, educational institutions, taxing masters, the entire legal fraternity, and especially to the business community, which is often the victim of high fees, charges, and costs in legal disputes. At the price of shillings 70,000 in Uganda, this book is moderately priced for the kind of value it gives to the nation.
Thank you. This book is valuable not only for practitioners, but also for students of law. As I want to repeat, it says casebook on lawyers' ethics, professional fees, and the charges. I cite cases of examples, very many here, including such cases as where Judge Odochi was faced with a bill allowed by the taxing master to the tune of 500 million shillings, and he reduced it to a mere 200 million. My judgments are there. One case in which Mulenga and Mukasa Chikonyogo and I appeared, they had charged and allowed, the taxation master allowed, in the sum of over 300 million, we reduced it to a mere 50 million. In another case, where I also sat with Justin Mulenga and Akarokola, the lawyer had demanded that his costs and the charges amounted to 750 million. This was confirmed by the Court of Appeal. When it came to us, we looked at the facts. We reduced it to a mere 5 million shillings. The most notorious of them, it is here, was where the lawyer fictitiously made a bill unrelated to the cases, and a certain institution is here, paid a colossal sum of money, and the part of it went to the registrar of the court. We quote them. My book named some of them. They are still at large. There is endemic corruption, endemic, in the Uganda judiciary, condoned and encouraged by government lawyers collaborating with dishonest counsel practicing there. As I speak now, I don't know, I will not embarrass you. There is a firm of lawyers called Sendege and the company. They are representing a lawyer. I know him. He used to work for the IGG, who, when my book was published, Evolution of Constitutional Law, publicly on the government, first time, the first edition, he was unborn. But he's claiming that we wrote that book together. And I should pay him the cost of 1 million, rather 100 million shillings, or acknowledge publicly that we wrote it together. Otherwise, he will sue me, and he has filed the case against me. If you read that book, I first published it in 1975, before this lawyer was born. Obviously, he must collaborate with him in his mother's womb. Now, I said, can you give me a copy of the plaint you have brought? Because I want to ridiculous. Sendege refuses. Then I invited him. I said, come here and I show you why I'm not liable and why your client is telling you lies. He said he would come. He didn't turn up. Sendege and the company advocates. One of you, if you know him, ask him that really you better go and see just Kanyama. I have no problem with him. I'm sure he's innocent. But simply to believe the story of your client without verifying the facts yourself is unprofessional. Now, I got sick. I have been reported dead by some media. So when I was in hospital, which was genuine, and the people said I had died, some lawyers, I know two of them, including one who is a Muchiga, called Dr. Somebody, they formulated a decree, first decree, that I owed them. One of them, I think I owed them 250 million. Another one, I think it is $1 billion. Another one says the case here, the one it is waiting for judgment. They never had it when but they pinned those documents on my gate, hoping that if I die, my estate and my family members who don't know anything would pay from my estate. So when I came, I was livid. How can the Ugandan lawyers behave like this way? I called that doctor, Muchiga. He has never answered my phone. Then I discovered that he's the same one who was suing a friend of mine for defamation of character. And I was practicing, I represented that gentleman. And my client died. And when he died, he substituted the other person's name with mine, and he continued suing me as if I was the guilty party. When all lawyers know, when you are suing for defamation of character, and that the one defaming you dies, that ends the case. The action dies. That case is still in the court. This is the kind of legal mess we are in today as Uganda. When I talked to some of the students, this booklet, challenging presidential election, and that is how I am going to judge you who are here.
Yes, Professor.
It is very simple, and it asks 3 questions. Museveni will be 83 or 84 come next election. You are younger people. Most of you were born during his reign. I certainly was born before his reign. I helped him to govern. Are you going to accept after this term that he's a proper candidate to govern this country for the next following 5 years until he's 90, 94? I am 92. If you offered me to be president, I would refuse. I would say it is not in the interest of Uganda that an old man should be president because you need him there. Then I want to remind you, because you don't have a reading culture which remembers mine. I went and addressed members of parliament until 2 years ago, no, until 3 elections ago. I was always the keynote address. I gave a keynote address to the new parliament, every new parliament. In the last one, when I last appeared, Professor Dr. Joe Anyango was my discussant. And we appeared together with the whole parliament, and the vice president was there. Museveni was not there, in Hotel Africana. Ministers were there. Prime Minister was there. The vice president was there. So I addressed them on the role of parliament and the functions of an ordinary MP. I remember I touched on the issues which later affected the rebel MPs. And I got a standing ovation by parliament. Then somebody asked a question. KANYEIHAMBA, you have said that the ordinary peasants, the ordinary people, don't have much say in the constitutional evolution of the country. I say that is absolutely true. The ordinary voters, the ordinary people, we don't participate in who is going to be our leader, who is going to the presidential candidate or his running mate. We are only told by the parties. They come, our candidate in 7 vote for him. Our candidate is Nobody Ma, vote for him. And we just vote. They never give us reasons why they are their candidate. We never weigh the importance to us. Then that is where Joe Onyango, whose brain really is quite commendable, as my discussant at Hotel Africana, made this statement discussing my paper, that in his opinion, the fathers of the Uganda Constitution were right to fix the term of office to 10 years or 5 years each. That after that, in the third term, if a man remains president, he will begin to show diminishing returns. That another term, he will be non-functional. Should he stay longer as Museveni has now, he becomes a liability to his nation. I agree with Professor Onyango that today Museveni is a liability to Uganda. That is why, finally, for my remarks, in this.
Yes, Professor is giving his final remarks. People stay on the call. Some few minutes.
In this book, I cite 2 famous sayings. One is that the pen is mightier than the gun. 2, that a corrupt leadership corrupts, and an absolute leadership corrupts absolutely. Then I say what is applicable to Museveni. And it is intended in this book for Museveni to read. I sent him a book, a copy of this. It says, the evil that men do lives after them. The good that they do is often interned with their bones. All these things are intended for our leadership. So I say here that the 11th Parliament, we shouldn't wait anymore. should move a resolution immediately to delete paragraph A of subsection 6 of section 59 of the Presidential Election Act, because it is unconstitutional, it conflicts with the provisions of Article 104, it is null and void. Secondly, it is intended to intimidate, frighten judges, and he who uses fear is evil. Then I say, Museveni must tell us in this term, this year, if possible, that he will be leaving office. Maybe next year, the after, certainly at the end of this term, if Ugandans, including you, accept him as president, then we deserve the leadership we get in this country. He's not a god. He's not immortal. And he has become very tired. And we are being governed by the likes of Akandoganoho, Salem Sade, by people like his son, whom Akandoganoho said he should become a businessman and leave politics alone, and by Mrs. Janet Museveni. He's pretending to take decisions, but he doesn't. By the time I left cabinet as a minister, I used to advise the president, please, can we stop here? You are tired. Can we stop here? You are tired. It would be on you in front of people. Now he has got another 3 terms. So he must. You must urge your MPs.
Yes, Professor.
Because Senator Muchegulanyi took these 100 copies of it and said he's going to distribute to all the members of the opposition, not necessarily his own party. And he will urge them this time in the 11th Parliament to move a removal, not a vote of no confidence, a removal of article of clause A, which I have talked about, because it was obtained by fraud, by bribing MPs with 55 million each, and it forced good people we used to know, the pillars of this country, Kategaya, Amanya Mshega, Miriam Matembe, Bidan Sadi, to be sacked from government. People. God has kept me going to pass this message to you and to the people of Uganda. I have nothing more to say.
Thank you so much, Professor. Thank you so much for sharing time with us. It really means a lot having the father of constitutional law sharing with us from the past to the present and in the future. You've had the history about how far we've come, and you've heard how impartial he is from his observations. Thank you so much, Professor. Professor, thank you so much for always allowing us to come here and you share with us. Professor has a foundation, it's called the KANYEIHAMBA Foundation, and I'm among the members. And I would like to urge you all to join the KANYEIHAMBA Foundation. And for more information, we shall be guiding you. You can reach out. I also want to welcome the new entrants, UC that have joined UC Law Faculty. And I want to wish you the best as you begin this new journey of pursuing law. I want to once again thank the participants that have been on the call. Thank you so much for spending time with us. I believe that you've gotten what you wanted. You always wanted to hear from the professor. Who is the professor that wrote for us constitutional history, the constitutional history that we studied? Who is the professor that gave the judgment in 4 Versus Anthony, which I know you cannot enter class when you don't know it. We've had a lot, and it's very unfortunate that we have to log out. Allow me to use this opportunity to invite the president, UC Law Society, main campus, to give a few remarks. I'll also invite the president, UC Law Society, Kampala campus, to give some few remarks. Thank you so much, Madam Elizabeth. You can please unmute and speak to us.
Thank you.
Thank you so much, Mr. Speaker. Good evening, ladies and gentlemen. I am really honored to be part of this session, and I take this opportunity to thank you all for joining us today. We have been conducting such similar series over the past few months and have hosted different prominent men and women in the legal space, and I believe that these sessions have been highly impactful and they have shed more light on the journey of a student of law. In case you missed any of these sessions, I urge you to follow the UC Law Society's YouTube channel. Many of these sessions are there and you can be able to get them. And so as I conclude, I really would love to appreciate Honorable Justice Professor George Wilson KANYEIHAMBA for accepting to feature in our final episode of the Eminent Speaker Series. I must say that this is a lifetime opportunity and we are grateful, Honorable Justice, that you have given us your time. May God bless you. May He continue to strengthen you. And I also pray that the students in attendance have taken down notes and that because of this particular session, we have been more energized to defend the temple of justice. I really hope that the lessons and the experiences of the father of constitutional law in this country have not left us the same. I pray that we shall not sit back in political fear, but that we shall be the generation of young lawyers that will defend the temple of justice at whatever cost. Thank you so much for joining in, and the UC Law Society continues to wish you better days ahead. We wish you a happy Independence Day tomorrow. I pray that we shall reflect not only on what our country ought to do for us, but rather on what we can do and on what substantial contribution we can make to our country. May God bless you all.
May He bless you too. Thank you.
Well, thank you so much, Madam President. UC Law Society, it seems like Mr. Dominic is not on the call. Mr. Dominic, are you on the call? Okay. Can we get someone to lead us in a closing prayer from Kampala campus? Well, if there's no one, allow me to. We have one of two new entrants that came with us in first year. Ladies and gentlemen, they are going to lead us in a word of prayer. Yes, thank you so much. Is it you or? Thank you.
Good evening, ladies and gentlemen. Let's humble ourselves for a closing prayer. Heavenly Father, King of all kings, Lord of all lords, we thank you for this wonderful day. We thank you for this session. We thank you for you brought us yet another day to this place, Almighty King of Kings. Father, we pray that whatever has been discussed or spoken has been held in our heads, Almighty King of Kings. Bless us as we move on to our journeys as being great lawyers, Almighty King of Kings, and let us use the knowledge we have been given to pursue it, Almighty King of Kings. Bless us this evening and all. In the mighty name of Jesus, I pray and believe. Amen.
Well, thank you so much, friends. May God bless you. Take care, and I wish you all the best.
Thank you, Mr. Convener, or rather, moderator. Thank you. And thank you for that nice prayer.
It was nice having
Thank
you
you.
hosting us.
As you can see, I've been talking since 9 what? Solomon. Since when? We started with the other lot